Section 4a is definition of law terms. We can't understand any of the law questions unless we understand what some of the words mean. We start off with the administrator. The administrator is the person that is responsible for administering securities laws in a state. So part of your test will be law questions. And there's two categories of law questions. There are law questions that pertain to state securities law, which is called the Uniform Securities Act. And then there will be law questions that pertain to federal securities law. Most of the time, state and federal law is similar, if not identical. Sometimes it's different. These first 5 sections of our law portion of the course are going to pertain to the Uniform Securities Act. So we'll get to federal law. It has its own section. It's the last section of the course within the law portion. On the score report for your exam, your last section on your score report is law. So, of course, on the real test, all the questions are mixed together, and there's state law questions and there's federal law questions. But I don't want you to be confused when I'm presenting this information. So the first 5 sections, within this law portion of the course are state law. And then the last section is going to be the federal law. So I'll make sure that you know where we're at. This is where we're starting. So the administrator is the person that is responsible for administering securities laws in that state. So there is this Uniform Securities Act. So the administrators attempt to have uniformity across state lines, although they're not exactly the same. But never will your test ask you a question about the laws of your state, because it is a nationwide test. They don't know if you're in Texas or if you're in Oregon or New York when you're taking this exam. So they're going to ask you questions about the generic form of the Uniform Securities Act. So we're going to talk about state securities law in a general form. So the administrator. An advertisement is anything used in the public medium to solicit business. It may or may not have to be filed with the administrator. An agent. This is where we begin the mental gymnastics portion of the course. So, law questions. The law questions themselves are long and wordy. They're written by lawyers who forgot how to speak in English. I hope you're not a lawyer, so I apologize if you are. But it's this idea that these are tricky questions, so be very careful here. If you represent a broker-dealer, which 99% of my students do, no matter what you sell or how you sell it, you must be registered as an agent. You must be registered as an agent. I briefly talked about this earlier on in the course, that when you take your Series 6, your Mutual Funds and Variable Products exam, or you take your Series 7, on those tests are written by FINRA. So they're written by a totally different organization than what writes your test here. This test here is written by the North American Securities Administrators Association. So they're written by different people. The Series 6 or Series 7, we call you a registered representative. So a registered rep. You buy and sell securities for your clients with your Series 7 license. With your Series 6 license, you can sell variable insurance and mutual funds. They don't call you a registered rep, though, on this test. They're going to call you an agent. So this is you. The U4 opens up your window to be an agent selling securities. So there's this important thing that I have to point out. Some of you will not have a Series 6 or Series 7 and won't ever be getting a Series 6 or Series 7, and thus are not ever going to be an agent. But the test doesn't care about that. They still care that you know about when you do need to be an agent, when you don't need to be an agent. Things about agents are going to appear on your test. So regardless of whether or not you are an agent or are ever going to be an agent, they're still going to ask you about it. So if you're never going to get a product license, then you're not an agent. But we're going to pretend that you are for now. So no matter what you sell, no matter how you sell it, you have to be registered if you sell securities for a broker-dealer. That one's easy. If you represent an issuer, so the issuer could be the U.S. government, it could be a municipality, it could be a corporation. If you're selling securities for the issuer, you may or may not have to register. You may or may not have to register. It just depends. If 1 or 2, you do not need to be an agent. I'll explain. If you sell an exempt security for the issuer, you need not register as an agent. If you sell for the issuer an exempt security, you do not need to register as an agent. What if you sell an exempt security for a broker-dealer? You must register as an agent, so be careful. But we don't really know yet what is an exempt security. So when a company has an IPO, in a normal situation, under the Securities Act of 1933, which is the first federal securities law that we ever talk about, registration is required. A registration statement must be filed federally under federal law with the SEC. And that's also true under the Uniform Securities Act, that a registration statement must be filed at the state level. When the test uses this term exempt security, you need to know what that means. It means that it is exempt from registration. So this is a security that does not have to be registered. It can legally be sold without being registered. In a subsequent section, we're going to make a whole list of exempt securities. I'm just going to give you a preview of them for now. We need to learn a few of them. So their rationale behind a security being exempt is one of two. It's either so safe that we don't require registration. Okay, don't say that to your clients, but that's the idea behind it. Like U.S. government securities are exempt securities. Municipal securities are also exempt securities. Or the entity itself that's issuing the security is already regulated by someone else, like stock or debt of a bank is an exempt security. Are banks already highly regulated? Yes. So the security that represents an interest in or a debt of a bank is an exempt security. So it need not be registered. So if you sell for the issuer an exempt security, you need not be registered as an agent. So U.S. government securities are exempt. Municipal securities are exempt. Stock or debt of a bank. There are more exempt securities. We're just not quite there yet. That's a preview. Or if you sell through an exempt transaction. If you sell through an exempt transaction. So whole section on exempt transactions coming up, but as a preview, a private placement is an exempt transaction. A private placement is a way in which a company can make no more than, under state law, 10 offers of securities and does not have to register those securities. The way in which they're sold is called a private placement. It's very controlled, and we'll talk more about it. Fiduciary transactions are also exempt transactions. So if you sell an exempt security or through an exempt transaction for the issuer, you need not register as an agent unless, isn't there always an unless? Unless you make a commission. If you make a commission and you're selling an exempt security for the issuer or you're selling through an exempt transaction, then you must register as an agent of the issuer. So they like all of those pieces of the puzzle. You would have to register as an agent of the issuer. There's one more thing here that I need to point out. We said if you sold for the issuer an exempt security, you need not register as an agent. If, however, you sell a non-exempt security, tell me, what do you think that means? If an exempt security need not register, a non-exempt security must register. Exactly. Write those things on your scratch paper. It sounds so hokey, I know, but do it. Because there's this thing that happens, the questions are long and they get stuck in your brain, and this will help you. If you sell a non-exempt security, this is one that must register. The security must be registered. Must register. So must you. If you sell for the issuer a non-exempt security, you must register as an agent of the issuer. You must register as an agent of the issuer. So a couple of questions in this area, so just be careful. An individual is not considered an agent merely because he or she is a partner, an officer, or director of a brokerage firm. If the partner, officer, or director of a brokerage firm limits his or her activities to managerial functions and does not attempt to affect securities purchases or sales, then that person is not considered an agent. But if they act in such a capacity as an agent, when Form BD is filed, partners, officers, and directors of the brokerage firms are automatically registered as agents. That doesn't get them out of any examinations that they would need to take. It just gets them out of the paperwork, the U4 form paperwork. All of that same information is asked for of them on Form BD. So it's really just getting them out of that. Anti-fraud rules. The Uniform Securities Act has anti-fraud rules. So there are state anti-fraud rules, there are federal anti-fraud rules, and nobody and nothing is exempt from anti-fraud rules. You don't ever want to steal money or engage in market manipulation or non-disclosure of a material fact. So we'll do a whole section that talks about all the bad things that you do not want to do. Nothing is exempt from the anti-fraud requirements of the Act. An associated person is any employee, manager, director, officer, or partner of a member, broker, dealer, or another entity, or any person controlling, controlled by, or in common control with that member. They are all considered to be associated persons. So these are basically everybody that works at a firm except for clerical staff. Except for clerical staff. Blue sky laws are state securities law. To blue sky an issue is to register that security for sale in a state. Broker-dealer. A broker-dealer means any person. Now they use the term broadly on this test. Do not just think of you. So be very careful when they say person. It could mean lots of different things. So a broker-dealer means any person engaged in the business of effecting transactions in securities for the account of others, that's the broker side, or for their own account, that's the dealer side. The test likes to describe to you who is not a broker-dealer in order for you to be able to tell them who is going to have to register in this state as a broker-dealer. So the following persons are not going to have to register in this state as broker-dealers. They are not broker-dealers. Agents. Agents are not broker-dealers. You are the agent, which is not to say that you can't start your own firm, but it's Form BD that starts your own firm, and that form is filed and you create a legal entity that exists above you. Agents are never broker-dealers. Issuers. Microsoft sold stock. They're an issuer. They're not a broker-dealer. Issuers are never broker-dealers. Banks, savings institutions, and trust companies are never broker-dealers. I have a lot of students that work at the bank, and here they are taking this class. But the bank itself is its own legal entity. Then there's the broker-dealer business. It has a different name. Sounds very similar, though, to the bank. And potentially there's another business called the investment advisory portion of the business. Maybe they even have a mortgage arm as well. But the bank itself, deposits insured by the FDIC, is its own entity. Banks are never broker-dealers. Persons who have no place of business in this state and who come into this state and affect securities transactions purely with institutional clients, like insurance companies, pension plans, mutual fund companies. These broker-dealers do not need to register as broker-dealers in this state. So the broker-dealer's out of New York. It's doing business in Arizona with an insurance company. Does it need to register in Arizona? No, it does not. If it has one public client, however, that lives in the state of Arizona, then the broker-dealer out of New York would also have to be registered in the state of Arizona. So there is no de minimis rule for broker-dealers. De minimis means a little bit in Latin. So if your customer should live in another state, the broker-dealer must be registered in that state, as would the agent who is conducting the securities transactions as well. The only exception to this situation, the broker-dealer's out of New York, the agent is also out of New York, the customer lives in New York, but takes a golf vacation to Scottsdale and wants to continue to do business with the agent, with the broker-dealer. Would that be allowed? Yes. Would the broker-dealer and the agent need to register in Arizona? No. So long as the customer is just temporarily in that other state. So if the customer picks up and decides to move to Arizona, then the agent and the broker-dealer would have to be registered in Arizona in order to continue to do business with that public customer. Consent to service of process is a form that is required to be filed by 3 parties. Consent to service of process. So consent to service of process creates jurisdiction across state lines. You might be registered in more than one state. If your client in another state wants to sue you, they can't sue you across state lines. So they issue a subpoena on the administrator of the state in which the client lives in, which is as legally binding as serving it on you directly. It's part of your registration process. Consent to service of process must be filed in every state in which you do business. So who has to file this form? Broker-dealers, agents, and investment advisors. So I have to talk about this for just a second here. So broker-dealer, this is your firm. With your Series 6 or your Series 7, you're an agent. This term right here, investment advisor, this is the firm. When a student gets their Series 6, Series 7, they become an agent. When they get their Series 65 license or their Series 66 license, they are allowed to work for an IA, that's the firm, as an IAR, as an investment advisor representative. So this is an interesting rule as far as consent to service of process is required to be filed by these three parties: agents, broker-dealers, and investment advisors. And that's the firm. Another way of saying this is that IARs do not file this form. Why? I don't know. I don't make the rules. I just teach them to you so that you can pass this darn test the very first time you take it. So be careful. That's a sort of interesting situation. An exempt security is a security that is exempt from what? Registration. It's also exempt from having to file sales and advertising. Nothing is exempt from the anti-fraud requirements of the Uniform Securities Act. An exempt transaction is a transaction that's exempt from registration and advertising requirements of the Uniform Securities Act. We talked about private placements and fiduciary transactions are exempt transactions. Nothing is exempt from the Act's anti-fraud provisions. The IA is the firm. So sometimes that's different from how we might talk in the real world. Investment advisor, and you think you're friends. But on the test, they're really good about not using the term IA to describe you. If they want to describe you, they're going to use the term IAR, Investment Advisor Representative. That's you if you're doing your 65 or your 66. As an IAR, you register at the state level. You register, that's the only place that you can register. You register at the state level. So you might be registered as an IAR in more than one state. We'll talk a little bit more about that in a minute. The firm is going to have to register either at the state level or federally. It depends. And it depends upon a couple of things. So the only person that can be federally registered in the investment advisory industry is the firm. The individual, the investment advisor representative, that's a state designation. So the firm, to register the firm, files what's called Form ADV. It stands for advisor. The firm is going to have to either register federally with the SEC or at the state level. If the firm manages a mutual fund, then the firm must register federally. If the firm manages a mutual fund, then the firm must register federally. We call this a federally covered advisor. Another trigger for federal registration has to do with what we call assets under management. The way the rule is currently is subject to change under the Dodd-Frank Wall Street reform legislation. It's subject to change the middle of the summer 2011. But if you've been following this new regulation at all, there's been a lot of deadlines within the regulation that have been missed already. So I'm never quite sure exactly when certain things are going to happen. I will teach you the current rule. I will teach you the new rule. Make sure you check the current PDF in the course for what is currently happening. It's not going to make you miss a question. If the rule has been enacted, I want you to go with the new rule for registration. So this is the way the rule is currently. If the firm has assets under management of over 30 million, then the firm must register federally. If the firm has assets under management of 25 million to 30 million, then it's up to the firm if they choose to register federally with the SEC, or they can choose to register at the state level. So this area here, it's up to the firm. If the firm has assets under management of less than 25 million, then the firm is required to register at the state level. So what is changing? What's changing under the new regulation is the size of assets under management. So what's going to happen is at the SEC level, we're going to have investment advisors registered that have 30 million or more in assets. And unless you manage a mutual fund or certain situations for hedge funds, all other IAs are going to have to register at the state level. The SEC has a huge job. So as part of the Dodd-Frank legislation, we're allowing the SEC to regulate less investment advisory firms. So really what's going to happen, what's going to stay with the SEC is the regulation of the larger firms. So the current rule is going to change. This is the newer of the rules. And you're going to find more and more IAs are going to be registered at the state level. So unless you manage a mutual fund or you're an IA with 100 million or more in assets under management, everybody else is going to become a state registered investment advisor. So there's a lot of paperwork that has to be filed in order to do that. There's no easy way around it. So it's quite a process within this industry. Something to note is that when a firm is federally covered, generally speaking, they aren't exempt from everything at the state level. Usually federally covered advisors are required to do what we call a notice filing at the state level. A notice filing at the state level for federally covered advisors. When an IA registers federally or at the state level or does a notice filing, there's always filing fees that are paid. There's always filing fees. A federally covered security is a security that's registered federally. Shares of a mutual fund are what we call federally covered securities. It's also true that anytime a company that has shares out there actively trading in what we call the national market system, which are companies that have lots of shares outstanding, a share price history is required to be in the national market system. So it's not everything that's in the secondary market, but it's most securities in the secondary market. When the issuer decides to sell more shares of stock, those more shares of stock are required to be registered federally. They're called federally covered securities. A fidelity, a surety bond, may have to be posted by the same persons that had to file consent to service of process: broker-dealers, IAs, and agents. A fidelity, a surety bond. The amount of the bond is $35,000. It protects clients from lost or stolen money or securities. So surety bond may have to be filed. Notice, I didn't say that it must be filed. If a broker-dealer or an investment advisor maintains net capital in the amount of the bond or in excess of the amount of the bond, they generally will not have to post the bond. So do know who may have to post it and how much. $35,000. Fraud is bad. Don't do it. Concealment, misrepresentation, or omission of a material fact or the truth to deceive or manipulate another party for unlawful or unfair gain. There's a whole chapter dedicated to all the bad things that you should not do. So we'll get to that shortly. A guaranteed security is a security that has a guarantee from someone other than the issuer as to the payment of three things: principal, interest, and dividends. So it's a definition question. You don't see these in the real world very often. But let's say that a subsidiary company sold a bond, and it's a guaranteed security, and the subsidiary goes broke. That means that the parent company will step in and pay the principal and interest to the bond holders. So you need to know what a guaranteed security is guaranteed to: principal, interest, and dividends. They make it sound like any one security is going to pay all those three things, which you know stocks pay dividends, bonds pay semi-annual interest, and repay their principal at maturity. Inside information. When should you trade based upon it? Never. Oh, I heard you say when you don't get caught. Not a good idea. Just ask the chemist at the FDA. Did you follow that at all? Oh, insider trading. They busted a janitor back on Wall Street before they had paper shredders. He was pulling out the minutes to the corporate board meetings and trading stocks based on that. Oh, he got caught. What a genius janitor. There was a chemist at the FDA that when a drug was almost going to be approved, he was having his family members buy the stock. That case is still pending, so maybe he's not really guilty, but that was a pretty good story. Don't trade based on inside information. If a client tells you inside information, tell it to your boss. Let them worry about what to do with it. Really, tell it to your principal. You can trade on inside information when it's public, then it's okay, then it's not inside anymore. An insider is any person who has non-public knowledge about a corporation. Insiders, by definition, include directors, officers, and stockholders who own 10% or more of any class of equity security of a corporation. So if you're defined as an insider, then you have to disclose your trades to the SEC before you trade them. So trades in your own company stock, obviously. So insider trades are what we call non-exempt transactions. Institutional investors. More than 50% of the trading that occurs today is trading that is done by insurance companies, pension plans, mutual fund companies, and hedge companies. The majority of the marketplace does not consist of everyday investors anymore. It used to, but it is not the case anymore. Institutional investors. An investment advisor. Any person who, for compensation, either a flat fee or a percentage of assets managed, offers investment advice, either directly or through publications or writings, as to the value of securities, or as to the advisability of investing in, purchasing, or selling securities, or who, for compensation and as part of a regular business, issues or promulgates analysis or reports concerning securities. This is the definition of an investment advisor. So this, a lot of times students have some issues with this. I want to make sure that we are on the same page when it comes to this idea. A broker-dealer buys and sells securities for its customers, that's the broker side, or for their own account, that's the dealer side. Some broker-dealers also charge a fee for investment advice. If that's the case, then the broker-dealer would have to also be registered as an investment advisor. So a fee is charged for investment advice. What is the fee? The fee can either be a flat fee, or more commonly, it's a percentage of assets managed. So anytime you charge a percentage of assets under management as a fee, That's a fee for investment advice. Another term that we'll see here is what we call a wrap fee, or a separately managed account fee. A wrap fee is a fee that wraps together the fee for the advice plus the transaction costs. So if a wrap fee is charged, the firm must be an investment advisor as well as a broker-dealer. The firm must be both in order to charge a wrap fee. Now, you're not the firm, although a few of my students will start their own firms. That's totally possible. Some of my students will file Form ADV, generally at the state level, and start their own investment advisory firm. Maybe you will do that. But what you're doing right now is you're doing your 65, or maybe you're taking your 66, which allows you to be an investment advisor representative, which means that you get to share in the fee that's charged for investment advice, or you get a percentage of the assets under management, or you get to share in the wrap fee. If you also charge a commission for transactions, then you're going to have to also be registered as an agent with your 6 or 7. So this is where we charge a fee for the securities transactions, a commission, I should say, a commission. Some of you will be able to do both, which is really what the wrap fee does, and some of you will only have your 65, and that's fine too. So when they say agent, that's your 6 or 7. When they say IAR, that's when you're working for the investment advisor charging a fee for investment advice. Could be a wrap fee. It could be a percentage of assets under management. I hope that helps. This is kind of a confusing topic. A lot of times my students, when I'm teaching in a live class, this is something that they've always wondered about. They weren't quite sure how it all worked. So hopefully that helps clear up the difference between the agent and the IAR. Of course, this all started because of the definition of the investment advisor, which is the firm. So that's Form ADV that is filed either at the state or federal level, depending upon the situation that's presented to you in the question.